strict liability, absolute liability, and vicarious liability. These are all liabilities under the law of tort. Everyone, welcome to another episode of Law of Tort, the series. If you're joining us for the first time, welcome. I am Saibi Wadi, and today we'll be discussing liabilities under the law of tort. Do make sure to hit that subscribe button to subscribe so that when we drop a new video, you'll be notified first. In our previous video, we discussed what exactly the law of tort entails, the meaning, essentials, tortious liability, and all the information a beginner is supposed to have when it comes to the law of tort. So if you haven't watched that video, kindly go do so, as it will give you a better understanding of the law of tort. I'll leave a link to that video in the description below, so do watch it. Back to our agenda for today. Like I said earlier, we'll be going deep into the law of tort. Today we'll be discussing the concept of liability within the law of tort. Now, in law of tort, liability refers to the legal responsibility or obligation of a party for the harm or injury caused to another party. In simple terms, liability is being held accountable for the damage you've caused or the damage your property has caused. The different categories of liability we'll be discussing today addresses various circumstances in which individuals or entities may be held accountable. We have strict liability, vicarious liability, and absolute liability. But today we'll be discussing vicarious liability first. Vicarious liability is also referred to as imputed liability. It's the legal doctrine which holds a party accountable for the wrongful actions of another party. Basically, it assigns liability to an individual who did not actually cause the harm but has a specific superior legal relationship to the person who did. Vicarious liability is commonly applied to in employer versus employee relationship, where the employer is being held liable for the actions of the employee, as long as the action was done within the scope of employment. This means that in vicarious liability, the employer will be held liable in cases where an employee causes any intentional harm during the course of his employment. For example, in cases where the employee's negligence leads to a customer's injury, the employer will be held vicariously liable. Similarly, in medical malpractice proceedings or court cases, a hospital will be held vicariously liable for the negligent actions of its doctors. Now, what are the elements that would need to be there to constitute the defense of vicarious liability? Let me tell you. Firstly, there must be the existence of a relationship such as an employer and employee, a principal-agent relationship, or a partnership relationship. Secondly, a wrongful act must be committed by an employee or an agent. Thirdly, the wrongful act must occur within the scope of the employee's employment or the agent's authority. Now, there are different judgments and different case laws in which the principle of vicarious liability has been used. The very first one is the case of Lister versus Esley Hall Ltd. In 2001. This case is a significant case in tort law. It deals with vicarious liability within the employment. The case established that an employer could be held vicariously liable for intentional torts committed by an employee if the torts were closely connected to the employment. In this case, a warden was employed at an annex of a boarding school for boys. His responsibilities included the day-to-day running of the school, discipline of the boys, organization of their daily activities, and supervision after the school hours. Between 1979 and 1982, the warden sexually abused several boys unbeknownst to its employers. The abuse occurred within several contexts of the warden's control and discipline at the boarding school. Now, vicarious liability can arise from unauthorized intentional wrongdoings committed by an employee acting for their own benefit. The connection between wrongdoing and the work for which the employee was employed determines the liability. In this particular case, the court rejected the restrictive view that vicarious liability only arises when the employee acts for the employer's benefit. The court held that there was a sufficient connection between the warden's employment and the abuse he committed. The warden's function was to care for the boys, and the abusive manner did not sever the connection between the employment. Accordingly, the employers were held liable for the warden's action. The next case would be the case of Morris versus C.W. Martins and Sons Ltd. This particular case is a very important English tort case that everyone needs to understand. In this case, the court held that employers are fully liable for thefts or negligence committed by their employees when handling goods they have a duty to protect. The petitioner in this case, Mrs. Morris, the owner of a mint stall, sent her coat to a furrier named Solomon Macbether in London. Now, Macbether called C.W. Martins and Sons Ltd, a reputable cleaning company, to clean the coat. While the coat was in their possession, it was lost. Now, a duty of care was held by the sub-bailiffs, which was C.W. Martins Sons Ltd, to take reasonable care of the forecourt. This duty was non-negligible, meaning they are personally liable for their employees' action. If the employee stole the coat or lost it, the employer C.W. Martins and Sons Ltd would still be held liable. The court held that employers are fully liable for the thefts committed by their employees when handling goods they have to protect. Now, this is all we have for today on vicarious liability. If you have any questions or doubts on this particular topic, do leave that in the comment section and we'll get back to you. Thank you so much for watching. For more such legal updates, follow IndiaLegal.